This is part 50 as far as our lecture series is concerned, and in this part we intend to discuss chapter 34 of the Criminal Procedure Code, which deals with disposal of property. And you have to start right from section 451 up to section 459 of the Criminal Procedure Code in order to understand disposal of property. If we read section 451, the explanation to this section clearly lays down, for the purposes of this section, property includes property of any kind or document which is produced before the court or which is in its custody. Any property regarding which an offence appears to have been committed or which appears to have been used for the commission of any offence. So what to do with respect to such property is dealt right from section 451 onwards of the Criminal Procedure Code. 451. Order for custody and disposal of property pending trial in certain cases. And it reads, when any property is produced before any criminal court during any inquiry or trial, the court may make such order as it thinks fit for the proper custody of such property pending the conclusion of the inquiry or trial, and if the property is subject to speedy and natural decay, or if it is otherwise expedient to do so, the court may, after recording such evidence as it thinks necessary, order it to be sold or otherwise disposed of. Section 452. Order for disposal of property at conclusion of trial. And it says, subclause 1 says, when an inquiry or trial in a criminal court is conducted, the court may make such order as it thinks fit for the disposal by destruction, confiscation, or delivery to any person claiming to be entitled to the possession thereof or otherwise of any property or document produced before it or in its custody, or regarding which any offence appears to have been committed or which has been used for the commission of any offence. Subclause 2 says, an order may be made under subsection 1 for the delivery of any property to any person claiming to be entitled to the possession thereof without any condition or on a condition that he executes a bond with or without sureties to the satisfaction of the court engaging to restore such property to the court if the order made under subsection 1 is modified or set aside on appeal or revision. Subclause 3 says, Court of Session may, instead of itself making an order under subsection 1, direct the property to be delivered to the Chief Judicial Magistrate, who shall thereupon deal with it in the manner provided in section 457, 458 and 459. Subclause 4 says, except where the property is livestock or is subject to speedy and natural decay, or where a bond has been executed in pursuance of subsection 2, an order made under subsection 1 shall not be carried out for 2 months or when an appeal is presented until such appeal has been disposed of. Subclause 5 says, in this section, the term property includes, in the case of property regarding which an offence appears to have been committed, not only such property as has been originally in the possession or under the control of any party, but also any property into or for which the same may have been converted or exchanged, and anything acquired by such conversion or exchange, whether immediately or otherwise. With this now, section 453 says, payment to innocent purchaser of money found on accused. And it says, when any person is convicted of any offence which includes or amounts to theft or receiving stolen property, and it is proved that any other person bought the stolen property from him without knowing or having reason to believe that the same was stolen, and that any money has on his arrest been taken out of the possession of the convicted person, the court may, on the application of such purchaser and on the restitution of the stolen property to the person entitled to the possession thereof, order that out of such money a sum not exceeding the price paid by such purchaser be delivered to him. Section 454 deals with appeal against orders under section 452 and section 453. Subclause 1 says, any person aggrieved by an order made by a court under section 452 or section 453 may appeal against it to the court, which appeals ordinarily lie from convictions by the former court. Subclause 2 says, on such appeal, the appellate court may direct the order to be stayed pending disposal of the appeal, or may modify, alter or annul the order and make any further orders that may be just. Subclause 3 says, the powers referred to in subsection 2 may also be exercised by a court of appeal, confirmation or revision while dealing with the case in which the order referred to in subsection 1 was made. Section 455 deals with destruction of libellous and other matter, and subclause 1 says, on a conviction under section 292, section 293, section 501 or section 502 of the Indian Penal Code, the court may order the destruction of all the copies of the things in respect of which the conviction was had and which are in the custody of the court or remain in the possession or power of the person convicted. Subclause 2 says, the court may in a like manner on a conviction under section 272, section 273, section 274 or section 275 of the Indian Penal Code order the food, drink, drug or medical preparation in respect of which the conviction was had to be destroyed. Section 446 deals with power to restore possession of immovable property. Subclause 1 says, when a person is convicted of an offence attended by criminal force or show of criminal force or by criminal intimidation, and it appears to the court that by such force or show of force or intimidation any person has been dispossessed of any immovable property, the court may, if it thinks fit, order that possession of the same to be restored to that person after evicting by force, if necessary, any other person who may be in possession of the property, provided that no such order shall be made by the court more than 1 month after the date of the conviction. Subclause 2 says, where the court trying the offence has not made an order under subsection 1, the Court of Appeal, confirmation or revision may, if it thinks fit, make such order while disposing of the appeal, reference or revision as the case may be. Subclause 3 says, where an order has been made under subsection 1, the provisions of section 454 shall apply in relation thereto as they apply in relation to an order under section 453. Subclause 4 says, no order made under this section shall prejudice any right or interest to or in such immovable property which any person may be able to establish in a civil court. Next section 457 deals with procedure by police upon seizure of property, and it says, whenever the seizure of property by any police officer is reported to a magistrate under the provisions of this code, and such property is not produced before a criminal court during an inquiry or trial, the magistrate may make such order as he thinks fit respecting the disposal of such property or the delivery of such property to the person entitled to the possession thereof, or if such person cannot be ascertained respecting the custody and production of such property. Subclause 2 says, if the person so entitled is known, the magistrate may order the property to be delivered to him on such conditions, if any, as the magistrate thinks fit, and if such person is unknown, the magistrate may detain it and shall in such case issue a proclamation specifying the articles of which such property consists, requiring any person who may have a claim thereto to appear before him and establish his claim within 6 months from the date of such proclamation. 458 deals with procedure where no claimant appears within 6 months. Subclause 1 says, if no person within such period establishes his claim to such property, and if the person in whose possession such property was found is unable to show that it was legally acquired by him, the magistrate may by order direct that such property shall be at the disposal of the state government and may be sold by that government, and the proceeds of such sale shall be dealt with in such manner as may be prescribed. Subclause 2 says, an appeal shall lie against any such order to the court to which appeals ordinarily lie from convictions by the magistrate. And then last section, section 459 says, power to sell perishable property. If, and it says, if the person entitled to the possession of such property is unknown or absent, and the property is subject to speedy and natural decay, or if the magistrate to whom the seizure is reported is of opinion that its sale would be for the benefit of the owner, or that the value of such property is less than 500 rupees, the magistrate may at any time direct it to be sold, and the provisions of section 457 and section 458 shall, as nearly as may be practicable, apply to the net proceeds of such sale. So this is what to do, or how property is required to be disposed of as far as the criminal procedure code is concerned, is dealt right from section 451 up to section 459 of the criminal procedure code. With this now, in the next part of our lecture, we intend to deal with chapter 35 of the criminal procedure code, which deals with irregular proceedings. Now this chapter is to be read subject to the other provisions with which you have already dealt as far as criminal procedure code is concerned. Some of the sections to which we had reference in the past also. For example, when we were dealing with charge, we dealt with section 464. When we were dealing with section 164 of the criminal procedure code, we dealt with section 463. When we were dealing with right from section 177 up to 189 of the criminal procedure code, we had reference to section 462 of the criminal procedure code. So, this is not the chapter with which it is necessary for us to deal in watertight compartment or in isolation. But in order to summarize the provisions with which we are dealing, in the next part of our series of lecture, we shall be dealing right from section 460 up to 466 of the criminal procedure code in order to understand provisions as far as irregular proceedings are concerned.